Osenga from the University of Richmond School of Law, and I'm going to give you the rundown on the Supreme Court's trademark law decision from June 30, 2020, in the case of U.S. Patent and Trademark Office versus Booking.com. You may know that you can't get a trademark on a generic term. That is, a term that denotes to the consumer a class of products rather than a particular maker of a certain product. Think of words like pizza or shoes. You can't get a trademark on those words because if you did, how would another company who wanted to sell delicious Italian pies or fashionable footwear describe to consumers what they were offering? Anyway, the U.S. Patent and Trademark Office, or PTO, had a long-standing rule that a generic term combined with a generic internet domain like .com would result in a combination that itself was generic and would not be able to be protected by federal trademark law. Booking.com is a travel company that allows you to book hotels and more on their website. They filed a number of trademark registrations, including their name, Booking.com. The PTO examining attorney and the Trademark Trial and Appeal Board concluded that the term was generic for the services the company offered. That is, booking just means making travel reservations, and .com means you can do it online. Booking.com appealed the board's decision to the U.S. District Court for the Eastern District of Virginia and submitted to that court evidence that the consuming public actually understood Booking.com to refer to a particular company available at that website. That is, it's not generic. And further, even if it was a descriptive term, which, not surprisingly, is a term that's descriptive of a company's goods or services, but isn't generic, it could be protected as a trademark because the consuming public had come to associate the term Booking.com with that specific provider. The PTO appealed the district court's determination that the term was not generic to the Court of Appeals for the Fourth Circuit, which affirmed the district court. In doing so, the Fourth Circuit rejected the PTO's argument that a generic term coupled with .com is necessarily generic, so the PTO then appealed to the Supreme Court. The Supreme Court's opinion focuses on three bedrock points of trademark law. First, a generic term refers to a class of goods or services, rather than any particular example of that good or service. Second, compound terms require the term to be considered in whole, rather than dissected into component parts. And third, the perspective that matters is that of the consumer. Analysis in this case, under those points, asks whether consumers, upon encountering the term Booking.com, would believe it to be a class of goods or services or a particular offering. As the court offered by way of explanation, would a consumer think of Travelocity as being a Booking.com? Nope. Not generic, case closed. Well, okay, so the court could have closed the case there, but the court also took the time to explain that the PTO's expansive rule that a generic term plus .com is pretty much generic in every case is a bad rule based on faulty reasoning related to old trademark cases. And in these cases, it was to companies named generic company, such as rubber company or pizza company or shoe company. Those are terrible company names, by the way, but they would also impede other companies who wanted to sell rubber or pizza or shoes. But domain names are different, right? They're singular or one of a kind. That is, only one company can have a website at Booking.com. On the flip side, the court was pretty clear that the singular nature of websites doesn't necessarily render a domain name protectable. Like maybe pizza.com is not protectable. What it all boils down to is that third point again, whether consumers perceive the domain name to refer to a class or to a particular provider or manufacturer. The Supreme Court's decision was 8-1, authored by Justice Ginsburg. Justice Breyer dissented, basically arguing that Booking.com is generic because it's a generic term plus a generic domain. And he also kind of discounted the evidence that consumers understood that Booking.com was a trademark. Anyway, that's Booking.com.